Hello there. Assalamualaikum and a very good day to madam. So my name is Putri Eliyana binti Rizwan Low, and today I'm with my partner, which is.
Hello, I am Nurul Izzati binti Muhammad Sahad.
So today, I and Wawa, we're going to discuss about the fundamental elements of agency relation under Nigerian commercial law. So we go into the next part. All right. So today's agenda is we are going to explain about the abstract and also the introduction, conceptual framework, fundamental elements of agency relation in Nigeria, and the last but not least is the conclusion. So we are moving to the abstract. All right. So in this article, so we find that the contemporary business deals and contract have increasingly depended on agency services. And in this article too, it also highlights an evaluation on the key aspect of the Nigerian law of agency against the background of the increasing usage of the services provided by agents in the progressively complex commercial transaction in an era of globalization. So we move to the introduction. This part, I'm going to pass it to Wawa.
Okay, so introduction is Nigeria law of agency is a founder principle on common law and judicial precedent. So second is increased number of businessmen and corporate institutions from across the global find it progressively indispensable to deal and related with each other through agent as the frontiers of international trade aspect. So that is the paper evaluated fundamental element of the law relating to agency in Nigeria. So last is examination the role and relevance of agent in commercial transaction in the country. So the conceptual framework is, in general, the person who seeks assistance is known as the principal, and the person who gives assistance is known as an agent. Basically, the article contains numerous definition and description of an agent and agency and the relationship between principal and agent itself. So agency is the relationship that exists between two persons, one of whom expressed or implied consent that the other should represent him or act on his behalf, and the other who consent to represent the former or so to act. So agent is the one who is authorized to act for or in place of another as a representative, and include person acting in the capacity of the park steward, rank collector, and trusted. So that is principally the one who is to be represented or on whose behalf to act is to be done. So basically, the long and short of is it that the law recognizes there is some circumstances the agent can effect the principal legal position by certain acts which is to performance by the agent are not really to be treated as the agent on acts but acts of the principal. So conceptual framework is an angel contract is similar to a generic contract, except under section 138 is it to provide that even without consideration, an angel contract is still valid and enforceable. It was thought that the relationship of principal and agent, which is known as the creation of agency, may arise in 5 ways. Second is express employment. 2 is appointment autonomy. 3 is ratification. 4th is the doctrine is stopped by implication. And 5th is necessity. So I pass to Putri Eliyana.
So I will be going to explain about the fundamental elements of agency relation in Nigeria. So based on the paper, it is stated about the issue involved on the basic qualities and texture of agency relation in Nigeria, with some case example that are related to each issue. So in this paper, there are 5 issues which are related to it, and I'm going to explain briefly. So the 5 issues related to the basic qualities and texture of agency relation in Nigeria. So the first and foremost, issues that relating to the extent of limits of the authority and power of an agent, where we can see the all cases in the first issue illustrate that the acts or action an agent effectively bind the principal, but the agent must at all time act within the scope of his express authority. So more than that, an agent must not follow his own interest to conflict with his own obligation to his principal. Thus, secondly, the legal position of the agent who has or has not disclosed his principal. An agent cannot by himself enforce the contract made by him on behalf of his principal. In this section, it is highlighted that the contract concluded by the agent acting within the scope authority for the disclosed principal is in the contract law of the principal, and it is the principal and not the agent who has the right to sue or to be sued over the contract. So contracts made through an agent and obligation arising from the action committed by an agent will have the same legal consequences as if the contract has been made and acted upon the principal himself, and principal has rights and liabilities in the contract made by the agent. So the agent will be held accountable on his own when the principal's name is not disclosed and cannot be prosecuted. So thirdly, the liability or otherwise of the principal for the cruel or criminal conduct of the agent in the performance of his duties as such. This can be seen where agents by law owe some duties to their principal, and thus may arise variously from common law and equity, but most importantly from the express or implied terms of the agency contract. Alright. So next, the paper also stated that it is apparent from the foregoing analysis that agents owe fiduciary and sundry other duties to their principal, which duty they must discharge with integrity and also transparency. Therefore, the 4 issues are the issues of tort or crime involving an agent. So the last but not least, agency relation that concern the remuneration or compensation of agents by the principal. It is a common knowledge that the principal's obligation to the agent include remuneration, reimbursement, and also indemnification. It is also stated that an agency fee is not payable in respect of a consideration that has yet to pass. This seems understandable in that why an agent deserves to be paid, reimbursed for expenses incurred for the principal, and indemnified under the agency contract. This must wait until he has offered his services. So, however, once he has offered his services, the principal is obligated to remunerate and compensate him, failing which he becomes liable in agent's fee. So we move to the last part, which is the conclusion. I will pass it to Wawa.
Thank you, Eliyana. So the conclusion is it include that the law of agency in Nigeria is founded on common law and equity, applicable and conciliated by the court. So this article is clearly stated on all topic, and all of this and move have been explored in this paper, with a view to highlight it. Nigeria law of agency as above all the large law of commission transaction. So thank you for Putri to conduct this presentation.
Thank you to Wawa too. So I am basically to summarize up and wrap up this conversation, which is the abstract and the article is very succinct and very direct. And also it also summarizing the purpose and also the detailed explanation and also the simplicity of the formulation of the sentence in these articles, making it very approachable and comprehensible for us to read and to understand this article. So that's all from me and also Wawa. Thank you so much.